You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. All right, so let's begin with the issue of the Auditor General rejecting and advising the presidency that he will not be doing any verification or validation of anything to enable the payment of almost 30 million, that is 29.7 million Ghana cedis in salary arrears, allegedly, to ex-MPs, ministers, deputy ministers, presidents, vice presidents from some 10 years ago. Are his reasons legitimate for rejecting and advising a rejection for these MPs' payments? Some of the potential beneficiaries have been heard saying that the Auditor General is so wrong. He had no business. He should have simply gone ahead and done the validation or verification he was supposed to do, rather than proffering a legal opinion on the process. All right, as you know, dummy level is not a pushover. Let's begin with Professor Kweku Asari. Prof, what do you make of this development from how you understand where the Auditor General is coming from and where the opponents are coming from?
Well, this is a very interesting governance problem. I'll start with the Auditor General, and you are right that he's rejected a demand from the 2005 to 2009 class of MPs. They wanted 30 million, and he's rejected that. Likewise, I believe, he's also rejected a demand from the DCs of the 1997 and 2001 class. So that is good. What I know, as a matter of fact, is that there has also been an approval for the 2001 2005 class of MPs, and they have been paid 10 million cedis. So we need to dig deeper to figure out how that approval was given that the Auditor General has unveiled a clear policy of not allowing this back payment. So that's the Auditor General's issue. Now, in terms of what we are dealing with, it seems to me that it is a conflict, a battle between the executive and the legislature, complicated by two factors. Factor number one is both the executive and the legislature are functus officials in this matter. Second, we are talking about a transaction that has been fully executed. What is the implication of this full execution and the fact that the people involved are functus official? Well, a couple of implications. The first is neither the current executive nor the current legislature have the power or authority to wade into this issue. In law, we say that the past cannot be recalled by the most absolute power, and that's for the executive. And for the legislature, we say But if an act be done under a law, a succeeding legislature cannot undo it.
Right.
So this controversy then can only be adjudicated by the judiciary. The people who feel aggrieved, if they want a remedy, they can go to court. And that's where the functus officio come in, because it is feared that a succeeding legislature and executive can enter into some side agreements and undo executed transactions, because most of what they do, or some of what they do, are not in plain sight. But with the judiciary, it is open, and we are all going to see what will go on if it goes to the judiciary. Now, if they choose to go to the judiciary, I'm talking about these old MPs and maybe some old executive members who feel done in, if they choose to go to court, they are likely to face three big problems. Number one, as a matter of law, there is something called the Limitations Act.
That's right.
In Ghana, I think it's NRCD 45 or 54. I can't recall. It's been a while since I looked at that.
Yeah, limitations decree. You go ahead.
What that tells you is if somebody owes you money, you have a certain number of years. I believe it's 6 years. And if you don't assert your right within that period, then you are barred from further trying to recoup that, because people must have their peace of mind. After 6 years, it's enough. If you haven't done anything about it, as a matter of law, you cannot do anything about it. Second, there is something that we call laches. Laches is not a legal right. It's an equitable right. Equity. As a matter of equity, you cannot sleep on your rights and want to assert that. It is said that equity aids the vigilant and not those who slumber on their rights. The third problem that you are going to run into is called estoppel by conduct. When they had this dispute in 2009 with Professor Mills, because Professor Mills basically rejected the Chinrihesi report. That's why we have this problem. And he paid them some amount, which I believe was based on the Ishmael Yamson report. But whatever it is, he paid them some amount.
Okay.
They did not reject that amount that he paid them.
All right.
They accepted
and
went home.
All right.
And been home for almost 15 years, because, 2009, almost 10 years. And then suddenly, they wake up and they say, well, pay us the difference.
The difference on the basis, pay us the difference on the basis of the Chinrihesi report.
On the basis of the Chinrihesi report, yes.
And like you say, they accepted not on the Chinrihesi report, but the Ishmael Yamson report.
Something else.
Right.
They accepted something else, I think based on the Ishmael Yamson report.
Okay.
But whatever it is, they were given something and they were happy with it. The transaction is fully executed. All parties have discharged their obligations. Professor Mills is not even here. Supposing we went to court, that would be another problem. The person who determined that they are not entitled to whatever they think they are entitled to is not even here. That's why there's a statute of limitation and there are latches, because people die, because witnesses disappear, and so on and so forth. So in my mind, there would not be any legal basis for them to successfully assert this right that they think they can assert.
Okay, Prof.
Now, something I know
Yeah.
this would address the question, but there's a deeper problem. And I think after others have spoken, I want us to examine critically the law itself, Article 71, because that's what we are fighting about, Article 71.
Thank you very much.
In my mind, as a country, we have completely misconstrued Article 71.
Okay.
And that's what is causing this problem.
Right. We'll come to that.
Let's talk about that when you had
Right. We'll come to that shortly. But what an exhaustive, researcher approach, a legal researcher, academic researcher approach that he has adopted.
Yeah.
If you take it from the point where he says, it would appear that you were paid on the Ishmael Yamson report. Now you are coming 10 years later to say that pay us a 20% increase
based on
the basis of the Chenrehese report. If we look at the Chenrehese report, we have been disadvantaged. So on the basis of that, give us a 20% salary arrears in increase. Is the Auditor General right in the conclusions he comes to? He begins to say one thing. He says, apart from the fact that the claim from the Forum of Former MPs is invalid, he says it's invalid. This is where some say he's put himself into a court interpreting law. But you expect that he should just sit there, anything you bring, he should pass it. He's a conveyor belt, that's it. He says the claim from the FFMP is invalid because the Chenrehese report for 2005 to 2009 was rejected. It may also amount to abuse of power or conflict of interest to make additional payment, 20% salary increase per annum for 4 years to former members of parliament covering a period of 10 to 14 years, especially when some of them are now the executive, i.e. the approving authority. You are no doubt aware that other public servants are denied their salary arrears resulting from employment and promotion through no fault of theirs whenever the arrears goes beyond a number of months.
Yes, yeah.
Then he makes one other point I should read. It is also a public knowledge. It is also a public knowledge that some MPs were or are undergoing police investigations for receiving double salaries, which implies overpayment. But several of the names are included in the list for the additional payments submitted by the FFMPs per Office of the President letter dated 22nd April 2020. It is my considered opinion that the former MPs are not entitled to what they are asking for, but it also came to me as a big surprise that our honorable MPs, former MPs, are making such a request at a time of a pandemic which has taken the entire world by surprise. Based on the above, I am unable to carry out the audit verification. So that's where he ends it. He raises a number of issues.
Yeah.
President Akufo-Addo is included. He's talking about people who are in government now. He says conflict of interest if they are the ones to approve, among others.
I think that it's very clear from the Auditor General's letter that there's certainly a situation of conflict of interest. The reason being that, and I believe historically, what actually happened was that when President Mills took over the reins of government, at the time, I think there were 2 reports based upon Article 71, sorry. There was the Ishmael Yamson report, which made recommendations with respect to the salaries and emoluments of Article 71 of his holders, especially those who were exiting, government at the time. And then there was the Chenrehese report. Now, I don't know the circumstances under which the 2 reports were.
That's why I wanted to.
No, let me come.
So that you can go on.
Yes.
I wanted to just give you a guess.
Okay.
Something.
No, I'll concede.
Okay.
Go ahead.
You see, the Kufuor regime was 2001 to 2008. Right?
Yes.
Now, Ismail Yamson's commission came in the first term. And then in the second term,
that's 2001 to 2004.
Yes, and then Chinrihesi came in the second term. When you are exiting, then you put up the committee to make the recommendations.
That's right.
So the earlier one was Yamson, that's the first term. Then the second term was Chinrihesi. That was what happened. So the two were for the two different regimes of 4 years. That's what I wanted to just draw attention.
Okay, well that is fine. Thanks for the clarification.
The auditor, the Auditor General said this. I think because of what he says, we should bring this one in. He said, he refers to a certain process that says, in that letter, His Excellency stated that Professor Mills is referring to, quote, on March 31, 2009, I set up a 5-member committee under the chairmanship of Mr. Ishmael Yamson to revisit the report of the Chinrihesi Committee on benefit for office holders under Article 71 of the 1992 Constitution. I have considered the Ishmael Yamson Committee report and have accepted the recommendations that the Chinrihesi Committee report should not be accepted for implementation for the following reasons. 1, there seems to be more than one final report of the Chinrihesi Committee. 2, the Ishmael Yamson Committee cannot confirm which of the final reports was allegedly approved. 3, there are uncertainties, ambiguities, and doubts surrounding the Chinrihesi report, leading to lack of authenticity. And finally, neither the President nor Parliament gave approval as mandated under Article 71(1) and 71(2) respectively of the 1992 Constitution of the Republic of Ghana.
Something you see, so that adds even to the confusion. Because then it means that if we accept as true the chronology of events as put forward by my learned friend, the DAG, then it means that there are two Ismail Yamson reports. The first was in 2000, the one for 2001-2004. And then the second would be the one that was, commissioned by Professor Mills, then President of the Republic in March 31st, 2009.
Right.
Now, if that is the case, the question then becomes whether the emoluments being sought now are based upon the second Ismail Yamson report or the Chinrihesi report, because it means that there was nothing contentious about the first Ismail Yamson report. In other words, those people were paid, all right, and they were satisfied with the salary, the emoluments that were paid them at the end of their term. And then subsequently, Chinrihesi came with another report, the authenticity of which the President Mills administration could not confirm. Right. And that is what, resulted in the setting up of the second Ismail Yamson, committee that came out with this report. So for me, I think that, as you pointed out earlier, there are very contentious constitutional and legal issues in this matter. And I must say publicly that some of the MPs, the former MPs led by my own former MP, Mr. Apasera, David Apasera came, they approached me, they wrote to the Attorney General. And the letter was referred to me, by my boss, the Honorable Mareta. And then I examined their, request for payment. At the time, from the facts that were given to me, and in the letter that I wrote to the Minister of Finance, I put in all the caveats, all right, to the extent that the facts that were given to me, okay, were the facts, that are new at the time of the issuance of the opinion. They had claimed that they were never paid any ex-gratia.
Okay.
Despite the fact that Chinrihesi recommended that they be paid. And so my opinion to the Minister of Finance was that they should pay them because that was an accrued constitutional entitlement. Subsequently, when I left the office of DAG, I met Mr. David Apasera and I asked him, what was the progress on their matter. He told me that the government was still refusing to pay. That is, the current government was still, the Minister of Finance was refusing to pay. And I told them, I said, look, you see, these are matters that usually you need a third-party arbiter to be able to say whether or not your entitlement is, legitimate. So I advised him, I said, they should get a lawyer, let them file an action in court, and then, the court will decide. Subsequently, I got to know that the High Court had thrown them out, and then they went to the Court of Appeal. And I don't know whether from the Court of Appeal they've gone to the Supreme Court. But from what Prof. Asari has said, and from all the issues that you yourself have raised, I think that this is a matter that should be determined by a third-party adjudicator, the judiciary.
But you are suggesting already that they took up a suit and were thrown out. We don't know if they were thrown out on
the basis of, let's say, limitations of actions, which is a possibility.
Right.
But then the question can then be raised whether, if it is a constitutional entitlement, whether the limitations decree will apply. Now remember, in 2004 and Attorney General, the court was very explicit that where you are dealing with constitutional entitlements,
can never be waived.
You can't equitable rules of extopel cannot be invoked, to prevent the realization of a constitutional entitlement. So there are, a lot of legal
equitable
issues.
principles generally don't apply where there are statutory or constitutional provisions.
And
covering the subject
on a last matter regarding the decision of the Auditor General and his categorical statement that it is invalid. You see, we take a very narrow view of the interpretation of statutes and the Constitution. And because in our jurisdiction, Article 2 of the Constitution says that it's the Supreme Court that can interpret and enforce the Constitution, we normally tend to think that anybody who offers an opinion on the Constitution, is usurping the powers of the Supreme Court. But that is not it. On a daily basis, the bureaucracy has to work with the Constitution. And they engage in constitutional interpretation of the provisions of the Constitution in order to be able to take steps, to guide themselves or a decision that they have taken.
In fact, Chapter 6 of the Constitution
actually, that is right.
Opens with the preamble that all
branches
of you, whoever you are, whatever you do, you must be on the basis of the application of the directive principles of state policy. And so interpretation is done by everyone else somewhere. So where do you stand on this?
In my submission, two quick things.
So your conclusion is that they should rather be thinking about a third-party arbiter
that is
going to court.
Yes.
But they have been thrown out by the High Court before.
Yes, you see, the caveat that I entered is very important because the facts they presented to me,
were different.
And you can take the file in the department to see what I did. The facts they presented to me were different. It was that they were never paid. They were not looking for
that they were not paid ex-gratia. It's not the question of coming for 20% increase as a result of
another controversy even arises from the submissions that we are all making this morning, a very serious one, and I want us to avert our minds to it. Whether when a committee is appointed by the outgoing president and makes recommendations, a new president can reject the recommendations of the committee that recommended the previous one appointed by a different president. That's another controversy.
Right.
Because
for payment to members of parliament.
Yes.
The committee's reports must be approved by the president.
Yes.
So you are paid on what the president approves.
Yes.
Not what the committee says.
Absolutely, I agree.
Good.
So what I'm saying is
that for the MPs, for the president, it is what you, the MPs, approve.
Yes.
Okay.
So what I'm saying is this: Chinrihesi committee was appointed by His Excellency President Kufuor to look into the emoluments. And the ex-gratia specifically. That was the mandate. And that was the outgoing president of the Republic at the time.
Right.
Now, I have heard arguments from some of the former MPs that the recommendations given by the Chinrihesi committee were actually approved by former President Kufuor. I've heard that on air. Some of them have argued it on air and etc., including the venerable.
The Auditor General appears to have done a thorough job and comes to the conclusion that he doesn't see the basis.
Yes, so you see, let me say that I have even sought clarification about that, and he said he hasn't found any report saying that the president, His Excellency, former President J. Kufuor, approved the recommendations. That's the challenge there. So, but as he has also indicated, he is saying that the recommendations that were given. He's made a very interesting argument. He says the recommendations that were given and the amount stated, indeed, is less than what they were paid, but that it had no presidential approval. And he goes ahead to say that at a later date, you realize that another group, that is the ones that came in the, I think the 6th Parliament or something, that the recommendations that were made, the people were paid more than that, meaning that the president approved something more than the recommendations had actually given. You understand what his argument is? He said that the president approved something more than what was recommended. So it means that it is the president's approval that authenticates it and not the committee's recommendation.
Right.
Now, this is the case in which the crop of persons who are to benefit, their argument is also that, look, this had been approved by former President Kufuor anyway. And as Professor Asari has said, it is very clear, if you read the 71-1, of course, you will see it very clearly that it is supposed to be charged on the consolidated funds shall be determined by the president on recommendations of a committee of not more than 5 persons appointed by the president. So no dispute about that. Then the salaries and allowances payable and the facilities available to the president, the vice, the chairman, and other members of council of state, ministers of state, deputy ministers, being expenditure charged on the consolidated, shall be determined by parliament on the recommendations of the committee referred to in one of this article. And for the purposes of this article, and except as otherwise provided in this constitution, salaries include allowances, facilities, privileges, and retiring benefits or awards. Very broad. So when Parliament approves that of the executive, and the executive approves that of Parliament, that's how it is done. So the controversy here
is it the case now that the succeeding Parliament has now approved what was to be paid to the executive?
That is the controversy that has to be resolved.
Yes.
Because you see.
So do you find that this Auditor General has exercised a lot of diligence in this process?
He has, but I think that he has done so well. I have no problem with what. But it looks like he also, along the line, turned himself to a court. Along the line.
Dominic has explained that, and you agree. Dominic has explained, and you agree.
Along the line.
You agree that this ought to be the case.
You see, because you see, he gave interpretations, and even the conflict of interest situation that we are talking about.
That's a matter of fact.
All of us, and Dominic, I want us to be very objective in matters like that. You see, when you talk about conflict of interest, you should look at it in a very holistic manner. Otherwise, at the end of the day, you will grind society to a halt because of the way things are run by us. Because if I am entitled to something, it's my entitlement. And I find myself in a certain position where I have a say in determining what belongs to me.
Okay.
Legitimately by the Constitution. So I say that by virtue of the fact that I'm in that privileged position, I will not be entitled to it because it will be conflict of interest. That should be another question we should be asking ourselves. I have worked
so what are you saying? You don't agree?
I've worked for a number of months.
You don't agree with what he says may constitute a conflict of interest because the people who are superintending this process are potential beneficiaries. And I go through the list. I go through the list and I see them. The president now is there. You see the difficulty you arrive at. You have the senior minister. You have Sechi Mensah Bonsu.
Let me draw your attention to something.
President Kufuor.
You understand?
You have Aliyu Mahama. You know, and it's littered, including with Courage Kwashiga, who God bless his soul, and one other, Idris Mustafa, who is gone. Right?
Yeah.
So what's going on? You don't think he's right in this?
I don't know whether you've understood the trajectory of events. You see, let me give you this clear example. Are we saying that those who you have mentioned are the only beneficiaries?
No.
It's a list of how many?
It's a list of 130.
Some of them are out of parliament.
Right.
Some of them are not in employment. So, by virtue of the fact that some beneficiaries are in government, those who are out should not benefit? Are they also suffering the same conflict of interest situation? Those who are outside, who are not within the ambit of the executive today.
He says, first of all, it's invalid.
No, You know that one too. I have dealt with a similar matter before at the High Court when I was in private practice, and I want to draw attention to it. Professor Asari sought to explain that the Limitations Act. You see, in that particular matter I'm talking about, we're able to establish before the court that yes, it was after the limitations, but from day one, we had been insisting on our right.
Explain to my audience first.
For example,
what do you mean by Limitations Act?
For example, the Limitations Act will give you a number of years after which a certain action cannot be taken.
Okay.
If it is land, we know how many. If it is so, in this case, it was 6 years. Now, when we went to court, it was raised by our opponent that we could not bring our right.
Let the people benefit directly.
Yeah.
If someone owes you a debt,
yes,
and you don't pursue the debt
at all
after 6 years,
that's it.
You have lost the opportunity to go to court to pursue the debt.
If you go to court, all he needs to do is to just raise it.
Okay.
Or somebody comes to occupy your land.
If you have a land and after 12 years,
after 12 years, the person occupies the land.
You have lost the opportunity.
In the case of debt, the limitations decree is very clear that where you write to the
that's where I'm coming to.
And then the debt is acknowledged.
Okay.
Where it is acknowledged,
then it doesn't apply anymore.
Then time begins to run from the date of the acknowledgement.
Absolutely. Yeah. In that case, we won it. And I was just coming to what my learned brother has said. You see, in that case, we won because we were able to establish that on a number of occasions we made demands and there were replies.
Yeah.
So then the judge said he was going to determine it from the last demand we made and the last reply we received. And that was 3 years. So it did not apply in that case. So in this one, limitations will only apply if for all this while no step was taken and no acknowledgement. But if it does not, then it means that time will not run. And then the lashes and all that are all applicable only in certain circumstances that the court will determine. But something that's one little point.
They are trying to fix your microphone. Once they fix it, well, I'll bring you back. But I wanted to go to quote specifically the Chapter 6 provision I was referring to, where you have continued to insist that no person can be interpreting the Constitution except the Supreme Court. Article 34, 1 says, the directive principles of state policy contained in this chapter shall guide all citizens, Parliament, the President, the Judiciary, the Council of State, the Cabinet, political parties, and other bodies and persons in applying or interpreting this Constitution or any other law in taking and implementing any policy decisions for the establishment of a just and free society. So the Auditor General is empowered by the Constitution to interpret and apply any law, including this Constitution, for the purposes of policy making and decisions and for establishing a just and free society. He says, literally speaking, this is invalid, it's unconscionable, it's immoral.
Yes, but you see, again, his determination is not final.
Of course.
That's one thing. And that is, again, something we have to look at. That the pronouncement that will be final will be by the Supreme Court. If they make a determination that this is the meaning, it is not subject to challenge.
So your conclusion is that what? The state should go ahead and pay, or that, like Chairman Sabonsu is saying, the Auditor General has no business doing this kind of research. He should simply go ahead and validate and verify.
From the letter I saw that went to the Auditor General, it was for him to validate. But he wrote an opinion.
Yes.
Why he wouldn't validate?
Yes.
So he invalidated what he was asked to validate.
Yes.
And he gave his reasons. Now that's why I told you, even off air, I was very clear in my mind that for me, I suspect that there will be a judicial pronouncement on this. I suspect.
All right.
And that will put issues in.
Remember that he has power under Article 187, to disallow certain expenditure. Now the question is whether he should wait for the expenditure to be incurred before disallowing it. As has happened in some, previous cases, or he can disallow it even before it has been incurred.
Correct.
So the alleged previous approval, if that one too is wrong, it's not alleged, it's actually factual. Factual. If that one too is found to be, not in conformity with the processes of law, the Auditor General today can disallow and surcharge whoever did it.
Okay.
All right. your very final
Yeah,
points,
you know,
and then we have Professor Asari say something briefly about his problem with the Article 70-71 process.
I was just trying to make a point. I think I want to correct a factual statement issue that I indicated.
Okay, once you remember.
It's with respect to this Ishmael Yamson's thing.
Right.
You know, I'm not too sure about the one I told you earlier on. You know, I'm very certain about what they did with respect to Professor Mills, but I'm not too sure about the earlier one. But what I just want to say is that, you see, I think that we are developing our legal jurisprudence. And this matter, for me, if someone is entitled to something, you know, Dr. Yine, you know, alleges they are entitled to if somebody alleges that he's entitled to something, as a nation, we should go through it without emotions. I saw a writer by a colleague member of parliament seeking to say that they should not make such demands because there's coronavirus. the Honorable Ablakwa. And I thought that it was below the belt. You see, sometimes let's be realistic in what we do. Let's not be idealistic.
But he's confirming what the Auditor General said.
Let's be idealistic. The point is that we can argue that there's a difference between you are entitled to, but the timing is wrong, and you are not entitled. Yeah. So if we determine that they are entitled, we can tell them to shelve it because we are incapable now. Okay. But to say that because of coronavirus,
let me have you comment briefly about the other aspect of the Auditor General's work, and then we have Professor Asari come in with his concerns with the Article 70, Article 71 process. The Auditor General has conducted another report of the ministries, departments, and agencies, and has found that 7,823 ghost names have been paid almost 600 million in salaries. 564.2 million has been paid. Again, how does this happen? A special audit of the Auditor General on payroll and personnel verification exercise had revealed that 21 ministries, departments, and agencies could not account for the whereabouts of the monies I have, of the employees that I have spoken about, and that the government, according to the Auditor General, lost the amount I have just referred to because they were paid to such ghosts. The audit verification of the nationwide payroll and personnel verification exercise from June 2018 to January 2020 was to provide an independent assurance on the overall payroll management system. The audit was conducted in line with the auditor's, powers according to the law that gives it. Now, maybe I should just refer to something here where the report showed that employees who had passed the compulsory retirement age were still on the payroll. There were salary grade mismatch and employees without biometric details. The Auditor General attributed these infractions in the payroll management system to weak coordination between the MDAs and the MMDAs on the one hand and the Controller and Accountant General on the other hand. Yes, Dominic. This ghost name thing. When will you...
I think, we have, as a country, invested heavily in systems and processes designed to prevent, ghost names from being on the payroll. Right. I think the Give Me system, you've heard of, right, is one of those. We've been doing auditing and then validation of employees. We've gone biometric. And I remember when I became Deputy Attorney General, I was asked to go to the Ministry of Finance, and then I got my biometric details taken, and I got issued with a biometric card. So all these processes that we've invested in are designed to prevent fraud in the payroll the payroll
controversial Snake software was also part
of that. All right. Yet it keeps recurring. Now, something what I would say is that we may not be able to arrest ghosts, but we can arrest human beings, living beings who are responsible for the existence of the ghosts. All right. I think this is a case of peer embezzlement, of public funds. I remember when we were in office, And of course, I'm sure my learned friend here, the DAG, they've continued what we left behind with respect to the National Service cases. You remember the National Service prosecutions, where the BNI did a very thorough job, very diligent, painstaking investigation that uncovered a lot of, malpractices with respect to the payroll. And there were ghost names. There were people who were on the payroll of the National Service that were actually non-existent employees. And as a result of that investigation, we recovered a lot of monies, from those who were involved. We also arrested and started prosecuting them. I don't know where the prosecution has reached us at now. But I think that is what we should do, stamp our authority effectively in order to eliminate the ghost from the payroll system.
Mm-hmm. Okay, yes.
Something who is a ghost? That's
like Dominic said, we should be asking the one who paid the ghost. Then we know who the ghost is.
How does the ghost draw salary and all that? You see, all these are systemic problems that we've noticed.
You and I have discussed this issue before.
Yes, on this platform. And I remember stating that most of it is greed.
Yeah.
I stated that most of it is greed. You see, you have a situation in the past. If you followed events very well, something in the past, it used to be the case that you could even have, at the end of the month, salary of about 40, 50 people transferred to a bank. And then there's a fraudulent manipulation and all the money is cashed and shared amongst people. And those people who actually took the money do not exist, including banks, bank officials. I even remember in one case, an accountant was arrested and all that. They will normally cash that in connivance with certain persons at controller, then they will meet at a point and share and all. In years past, it happened. And I think those were the reasons why in embarking on the journey to clean our payroll of ghosts and all that, we put in place certain stringent measures to be able to curb this, including but not limited to biometric verification and etc. So what beats my imagination now is how people who have been biometrically verified turn out to be ghosts. That's what beats my imagination. You've been verified biometrically and you've been put into the system and you are being paid.
As for those who are retired and are still receiving, that may not be too much of a difficulty.
After that one, we could just say that it's systemic, isn't it? But you have gone there, you've applied for a job, you've been recruited, you've gone for verification, and then you've been paid. And at the end, it turns out that you are a ghost when you have been verified by a verification machine. It's something that beats my imagination. But sometimes too,
there have been occasions where it has been found that somebody is taking something in the name of the ghost. So that is also a place
there's
to
also something that I want us to look at. You see, in the end, you realize that some of the people, not all, actually exist.
Okay.
And they work. But at the time of verification, they were not present. You have those ones who coming up every now and then. You disclose these figures, and when you go back to the ground, you realize that sometimes what they do is that they say all workers of this department meet on this date at this particular place for us to do verification, whether or not you exist and you are human. So when they go, it is not 100% attendance. So it is from these that they gather these facts.
Okay.
So absentees, for example, who genuinely may be working but could not actually attend the process of verification could be declared as ghosts.
Let's go to Professor.
But the majority of these, by and large, are actually ghosts.
Thank you. Let's go to Professor.
You should arrest the human beings who are behind
who are behind that. Thank you very much. Now, Professor Asari, there are many who are wondering what's going on in this country. There are teachers who are employed, and it takes 2 years, 3 years, some do more than that, and they have not yet received their first paycheck. And yet we are paying ghosts. Tell us what you think about this, and then briefly deal with the problem you have with the Article 70, 71 issues. Sorry.
Samson.
Yeah.
I think I agree with my friends Dominic and Joseph. Look, these ghost problems are as old as the Republic itself. Every year, the Auditor General does the work and he reports that they are ghosts. We talk about it for a few days and then we move on our merry ways. Nothing ever happens. So to me, it's no longer interesting that they are ghost workers. What is interesting for me is who is creating these ghosts and why don't we go after them?
Right.
When you look at the report, I will highlight 3 ministries. Ministry of Education alone has over 5,000 ghosts, and it is alleged that payments to these ghosts exceed 200 million. Then Ministry of Health, 1,300 ghosts, payments exceed 127 million. And then local government ministry, 548 ghosts, payments exceeding 34 million.
Ministry of Information has only 1 ghost. That can be a genuine error.
And conduct a forensic audit of the ministries. I'll go beyond a payroll audit and do a forensic audit with an intent to figure out what specific schemes are enabling these ghost payments, who are the ringleaders of these schemes, so that we can administer a blow to them that will strike fear in anyone who intends to bring up a ghost scheme to other departments. Now, when you look at the report, it looks like the voters register. Retired workers not terminated, you know, in the voters register we have dead people not removed. Duplicate social security numbers, okay, like duplication, paying people who have not been biometrically verified, even though that is not supposed to happen. Personation, that is using other people's qualification or using other people's voters' card to vote. One bank account that allows about 30 or 40 people to deposit their paycheck. That is a no-no in any payroll system.
All right.
Several suspected fraudulent certificates used for employment. Over-leveraged workers. There's a policy that no worker be allowed to deduct half of his salary for installment payments. But that's not followed. They have invested in an Oracle platform. This is a beautiful platform. And you can configure it in ways that enable some validation controls. But they don't do that. Why don't they do that? They don't do that because they want these things to persist. And so it's a systemic problem that is linked to the earlier problem that we described. Because you see, people see the tone at the top. And when they are unhappy with the tone at the top, well, they are not at the top, so they cannot have Ex-Gratia, they cannot be paid 20 years back pay. So they also design their own schemes. And unless we figure out how to stop the problem at the top, these other things at the bottom will continue. Now, on the Article 71...
No, just a second. Even the chieftaincy ministry, that small ministry, we cannot ensure that there's no ghost name there. There are 23 ghost names there. As an accounting professor, what do you think should be done beyond the other softwares you are recommending to avoid these things happening?
That's what I was talking about, the validation controls. When you buy the Oracle platform, it is set at a default value. So the controllers and accountant general's department should go in and configure it and say, for instance, don't pay unless you are biometrically verified. The only reason somebody can pay if it's not biometrically verified is because you have not turned on the validation control.
Okay.
These validation controls are there for a reason, but people subvert the control system by deliberately not turning them on. That's why all these things are happening.
Okay.
If you have a good accountant who turns these things on, then all the control problems will disappear.
Okay.
Then what you have left is the fraudulent problem.
Okay.
The fraudulent problem is where I call for a forensic audit.
Let's spend the next 4 or 5 minutes to hear your concerns about the Article 70, 71, matters.
Samson, if you look at Article 71, it is an anti-corruption article. It's an anti-corruption article.
Okay.
Why do I say that? Read it carefully. It says the president sets up a committee. The committee makes a recommendation. The president approves the package for the parliamentarians, and the parliamentarians approve the package for the executive.
Right.
You see that?
Yes.
Why? Why is the president approving the package for parliamentarians and the parliamentarians approving for the executive? Because we are afraid that if the president approves his own package and parliamentarians approve their own package, then they are going to just give themselves some hefty bonuses that the country cannot sustain. Now,
on the other hand, if the president treats the parliamentarians well, they will also treat him well.
Exactly. I was going to go to that.
Okay.
That if you just stop at what I read, then you are not really interpreting the Constitution carefully. You are missing the anti-corruption element in that article. That article also implies that the president and parliament should not be allowed to collude to take care of themselves. That's what it means. And then thirdly, the people themselves have to exercise some oversight of what is going on. When you put all that together, it basically means no president or parliament should be allowed to determine their own package. So if I'm the president today and I set up a committee and the committee comes up with some recommendations that I accept, that should take effect prospectively. I should not benefit from that, and the parliamentarians that I work with should not benefit from that. So this whole thing should always apply prospectively. And we are doing it so backward that we are now allowing it to happen retroactively. Second, an intervening election must take place before the recommendations take effect. So if I am the president in 2016 and I approve something, that should take effect not in 2016, maybe not even in 2020, but in 2024. Otherwise, you are going to defeat the whole purpose of Article 71, which, as I said, is an anti-corruption article, making sure that people are not taking care of themselves. So the idea that whenever the president is living, he can recommend certain things that take retrospective effect, that is so wrong. There's just no organization in the world where people's compensation package are determined after they have finished working. No. When you come in, your compensation package is known, and that's what it is.
Yeah. Okay.
So when we bring in a class of MPs, their package should be whatever was there when they got elected. Yeah. And then if they decide, and I think that these recommendations and these committees should not be set up every 4 years. Maybe they should be set up every 10 years. And then their recommendations bind for the next 10 years. Then after that 10 years, we set up another committee, and that committee makes its own recommendations.
All right.
The way we are interpreting it is just funny. Every president comes in, he sets up his own committee. The committee takes care of the president and the parliamentarians. It defeats completely the whole purpose of Article 71.
Thank you very much.
We are literally interpreting Article 71 in a way that no employer would do. And the reason this happens, Samson, is because we, the people, are not too vigilant. You know, in the US here, let me tell you something. The Congress can increase its own salary, but they tried it before, and the next elections, it was bloodshed. Just about every congressman lost his seat. The people were so upset. So now, what happened? Even though they can increase their pay, they never touch it. Congress's package has not been adjusted for about 15 years. Why? Because they are afraid of the people. Our politicians are not afraid of us. They know that we will just talk. I mean, Prop will come on Newsfile. He will make some good points, but nobody will, take it seriously.
Interestingly, Professor Asari, the two MPs here are adding them with you. They are supporting the point you just made and the recommendation you just made. I suppose that is the reason we should not throw out the Constitution Review Commission's recommendations. An emoluments commission that should be taking care of these things, so that we don't do scratch my back, I scratch yours. What do you say about his recommendations? What do you say about it? You were all nodding and saying yes, yes.
I think
I want my audience to hear you loudly.
If I were sitting on a judicial panel with Professor Asari on this matter, I would have said that, I agree totally, absolutely with what Martin
has nothing useful to add.
And I have nothing more useful to add. But let me say one thing respecting the retroactivity, the issue of retroactivity. Something, the problem we have is that parliamentarians often come in, an executive comes in, and they start work without knowing what their salary, and emoluments are.
Right.
All right. So you come in and you are being paid the salaries and emoluments that pertained at the time that you were elected.
Okay.
So you are sworn in on the 7th of January. You are not given of course, because we are not appointed, we are appointed by the people. So we are not given an appointment letter.
Okay.
But you are not even communicated to with respect to how much you are entitled to by way of salaries and emoluments.
All right.
And so, towards the end, when people know that they are now exiting, when the president, of course, has an election to contend, then we think that, it's now time to set up a committee to make recommendations about the salaries. And that is how come arrears are often a problem.
All right.
You see, because if you know your salary, from the onset, there's no reason why, the issue of arrears will come in. So I think to solve the problem of retroactive payments that Professor Asari has eloquently, pointed out, we should, make sure that immediately we come into office, from day one, the salaries and emoluments are
right. Thank you very much. Yes, in a minute.
Without amending even the Constitution, as you have rightly indicated, without even amending it, what I think we should do is that nothing ties the president from coming up with this committee in January, when we are sworn in, so that by February, March, this is in place.
All right.
And then you start taking your salary.
Okay.
Because you see something, we may be grappling with a bigger problem in future. We don't even know what may happen in future if we continue to have it the way it is. Because somebody says he's entitled to something, another person says you are not entitled to. If it had been determined from the very day, in fact, people we employ, what do? In the appointment letters, we state what they are entitled to.
Okay.
But we go in there, we are not aware of how much we are entitled to. It is only when we are exiting that we get to know and all that. And it's a practice that has continued. Either we do the constitutional amendment, or I think that we should have it done in January as soon as we are sworn in.
Thank you very much. How many times has this been advocated? For as long as I became politically aware. But it's there, nobody bothers. Is it because there's some benefit to it? Okay, so the case you referred to, I am reliably informed that the Court of Appeal, the one at the Court of Appeal, as to their payments, the MPs, former MPs, a judgment will be delivered in June. So hopefully they will get to know. So why are they in court and then they are seeking through the sort of back door to have the monies paid? And
that's interesting.
The question that the court is to determine more critically is whether the committee can make provision for pension for parliamentarians, deputy ministers, and ministers when the Constitution does not. That it appears to be the bigger issue to look at. We are taking a break, but before we do that, an MP Kodo sent me a message, and he suggests that the President Mills may have been wrong if President Kufuor approved the report, and then he decided when he took over to now seek to vary that report. So I think others have said here that would be difficult in a court of law. Kweku Bako Jr., who has always been so helpful, rare artillery support to me when I sit here, says that there was and there is only one Yamson Committee report. The Yamson Committee report was set up by the President Mills on March 31, 2009. It presented its report on May 31, 2009. JoyNews Committee produced two reports, an interim one, June 2008, and the final one, December 2008. JoyNews Committee was set up by President Kufuor. Before all these reports were the Green Street Committee set up by President Rawlings. In spite of the apparent rejection of the JoyNews Committee report by President Mills, there is evidence to the effect that members of the Parliament 2001-2005 were paid some monies on the account of salaries and rent based on the JoyNews Committee's report, which was presumed rejected and replaced by the Yamson Committee. This is contained in a letter signed by Dr. Kwabena Dufour and dated January 5, 2010. Another evidence of the JoyNews Committee report being applied is Chief of Staff Newman's August 24, 2011. And he has shared some of those letters with me. He concludes that if the rejection of the JoyNews report had indeed stood, why were payments made on the basis of it? That's an intriguing point. Or did the Mills administration beat a retreat? Some critics questioned the constitutionality of Mills's rejection of that report. And I think that is a matter of public knowledge. We take a break here, and when we return, we will find out whether you belong to the majority of the 5 judges in the Amidu H case, or you belong to the minority, the dissent position of the 2 who say that someone who came to office when he was 66 should not be allowed to continue in a public office where the Constitution says the public officers must retire compulsorily at 60, or if they got a contract at 65. Professor Asari has written, and he says the Supreme Court majority made some very wrong theories and analogies. He says the interpretation that they did undermines constitutional theory, and it is a misguided, purposive interpretation. The Supreme Court, however, is of the view that Dominic and people like Professor Asari are dealing with a solitary provision, narrow interpretation, not a holistic interpretation, which is very dangerous and does not allow our Constitution to grow. We'll be right back, and joining us to add to that discussion will be the other Deputy Attorney General, Dominic, Godfred Yeboah Dame. We'll be right back.